Yes, good morning. For those who have turned up in time, Anna was apologizing for everybody who might have not yet come here. But I think let's start with the recap as the others join us. I know this town is difficult to navigate. Yesterday it took me almost 3 hours to get home. I don't know you people should stop buying cars. Hmm? You started the number plate UAN like a month ago. You are now at UANT. Why are you putting all these cars? Eh? I think there should be a moratorium. Nobody buys cars for the next 1 year. Everywhere I turned, I went through Gogo, there was a jam. I turned around back, went towards the Ginger Road, the jam was. I actually ended up just sitting and drinking coffee somewhere for about an hour. Okay, so recap. I'm glad that from what some of you have been telling me this morning, you think this is an area of the law that is not just of interest for those who might want to litigate before the East African Court of Justice, because that was the drive, but also for people to understand good governance and the rule of law from a perspective of basic public policy aspects, but also that this is an area that some of you can step in and look at opportunities for legal practice beyond litigation in terms of engaging clients with regards to trade. We might not have had the opportunity to do that in 1.5, 2 days. But I would encourage that once you get the materials, look at the materials, do self-learning, teach yourself, go on the website and find what else you can find on ESC. That should be the starting point. Don't try to rush into the bigger continent. First start with ESC, then you can move to African Continental Free Trade Area. In any case, the regional economic communities are the blocks for the continental. So you first start from the region, understand it, because you can't jump onto the continental without understanding the regional. The continental framework is based on what is happening at the regional level. What are the regional frameworks, ESC, COMESA, ECOWAS doing? So start from there. As I said, self-plan, find time to explore opportunities you can create for clients in your firms. So just to recap, yesterday we did a number of things. The afternoon I introduced the community, ESC as a regional community. The term usually is regional economic communities, so they are RECs. And it's primarily, the primary purpose of the ESC is regional economic integration or regional trade integration. And that's why you find those pillars, the pillars of a customs union, a pillar of common market, a monetary union, that people should be able to then trade freely within this bigger market of close to 300 million people, that you remove the barriers to trade. You have a monetary union when it eventually comes, where you have one common currency. One of the problems now, I think, for trade is the fact that you have multiple currencies. And usually the dilemma is that then you say, okay, when you're even thinking of buying goods from Kenya, you first say, okay, what's the dollar rate? Then, so you first turn the Kenya shillings into dollars, and then look at how much then translates into Uganda shillings. You have a medium of a different currency, which is not even ours. We're often very reluctant even to think of Uganda, Kenya shillings. Right now, there are a number of countries where if you are paying tax for, say, digital services, Tanzania requires you to pay in Tanzanian shillings. That's the first primary currency. Then you can another currency. Rwanda, every contract or transaction will be based on Rwanda franc. They don't want you to transact in anything else. So I was actually shocked when I saw the bills that Uganda prepared in March for digital services tax in dollar. I would have thought that they would be thinking of our local currency. But in future, the idea is that all these currencies will disappear and you'll have a common, maybe East African shilling like it was between 67 and 77. But that's down the road. I'm told they are still fighting over where the central bank would be. The African. Well, but eventually, ultimately, it also comes down how do you, because even the European Union, you know that the British have still insisted on keeping the pound. But even when the euro was issued, they had to first of all deal with the intricacies of how much the volume of the various local currencies now translate. That's what will happen. But let's hope that that happens. So that's the community we're working with. I took you through the community. So it's broader than the treaty and the protocols. So that means you need to read extensively in order to understand. You need to look at the acts of the community. I gave you samples of them. When eventually you get the flash drive, there will be more insight there. Keep on a lookout on any other acts that are coming out and amendments. So for instance, as you are reading the East African Community Customs Management Act, they keep to the amendments that regularly pop up. As I was telling you, the latest, I think, is either 2020 or 2021. And so like we amend our laws, the acts of the community also get amendments over time. So look out for those. And each time you are reading anything to do with the treaty, also look at are there acts that give effect to those particular provisions of the treaty. So for instance, you have the anti-competition provisions in the Common Market Protocol. Look out for the competition, East African Community Competition Act. And just like we do, under acts we have subsidiary legislation. So within the same community, you have regulations, rules, and all that. So under the protocol, for instance, you have the rule of origins, origin. I'm even forgetting. But anyway, the Competition Act has its own rules. So look at those regulations and rules. If you're going to look at the Common Market Protocol, bear in mind there's a whole batch of rules that are supposed to be annexed to the protocol. But most times when you get the protocol, the version that you'll get, it doesn't have those annexures. And so be attentive to those annexures because then they contain the rules, the principles on which professions or which, how do I call it? What sectors can be permitted for movement of people? As I said, the rules of origin, rules. So basically, look out for everything that I've tried to capture most of those and put them in the drives for you. And then the directives. Just like we look out for our gazette, look out for the East African Community Gazette. It may not be regular. Yes, I was saying the Gazette, if I remember last check, there was, I think, January up to March of 2023. So keep checking out those Gazettes. It gives, sometimes they are not just the duty remissions that I was talking about, but there might also be instances where the Council of Ministers has issued legal notices that speak to the common external tariff. Where they're making adjustments and all that. So you need to pay attention to those. Especially, as I said, the people who have clients who need raw materials. The bulk of those are usually because you are bringing materials for purposes of processing, producing, and all that. Sometimes when I read through them, I don't understand most of the raw materials, but I'm sure your clients who are in certain sectors would understand. So keep on the lookout for those. The other thing we covered yesterday was, which the Deputy Registrar addressed, was the EACJ as the regional court. We touched on its jurisdiction, its structure. It's a two-tier court now, so the first court that division you engage is the first instance division. And then you'll eventually, if you need to appeal against the judgment of that division, you appeal to the appellate division. But as also pointed out, there are certain areas in which the appellate division has original jurisdiction. Preliminary ruling jurisdiction, which we are going to concentrate this morning for the rest of the training, is one of those. So you don't ask the National Court to refer and seek a preliminary ruling before the first instance. That can only go to the appellate division. And there's a reason for that. You want that ruling to be final, so that the matter goes back to the National Court. For the National Court, they need to use the ruling to dispose of a matter before it. Arbitration is the other, and then advisory opinion. So those are strictly the appellate division has original jurisdiction. We also looked at, as I said, engage the jurisdiction, who can appear before the court. Relation persona is who is entitled to appear and who can be brought before the court. And we pointed out the list that includes legal and natural persons for claims by persons against and then you have the potential respondent before the court, the state parties, partner states, the community and its institutions and organs, general, or for the institutions, they can be sued in their own behalf. And then we talk about the 2 months. So when you are to go to the court, pay attention to the 2 months limitation within which you must file a reference. The 2 months doesn't apply to claims under Article 31. So if you have an employee of the community who is still an employee, don't bring a claim under Article 31 of someone who has left the community. The person must still have employer relationship with the community. Either they have disgruntled about pay or some other thing. Interestingly, because we have never really had one where the court has to dispose of an employee-employer relationship, it's difficult to see what kind of substance of the dispute would be. But I think you can draw experience from SADC. They've had so many employee disputes and COMESA. So if you can go to the SADC tribunal, even though it's in limbo at the moment, I'll try to see if I can get them. Let me just remind myself to get you the employee disputes before the SADC tribunal. Most of them actually involved people who had expectations. They were still in employment, and then they had asked for renewal of contracts and those kind of things. And the question that legitimate expectation that if you do a 4-5-year term of employment in a particular position, that they will give you at least an extension of a contract, at least a second contract. So those are the kind of things that are there. Yeah, so I'll get that. Now, in terms of good governance, as I said, we didn't go into much depth. We just highlighted Article 7, 2 and 6D of and what the scope of those those principles are. But we're going to give you the slides of the presentation, so I'm going to create a folder for that, so that you can, what you displayed, you can also look at them. As I said, do self-learning and further learning. But what I've done is, in this slide, I've told you that the best way to understand good governance and the rule of law, as the court has articulated in its decisions, look at that resource book, that resource text, the source book on good governance and the rule of law. This is actually the second edition. By the way, we forgot to mention that. The first edition was published in October 2021, and it just came out from, when sometimes you do training, and this was judges. There were a number of new judges in the East African Court of Justice. So they thought that their proposal was that we do the PowerPoint presentations and the hyperlink the cases we refer to in the PowerPoint presentation to the website. Because some of them were new and they needed to see quickly how do we learn. And remember, they're like you. None of them ever went through a formal course on EAC. A good number of them were judges before the National Court, so they had no exposure. Now all of a sudden you have been seconded by your government to go to the first instance division or the appellate division, and you're basically like everybody else, fresh and unknowing. So we said we can do better. My discussions with Mr. Gima that we can do better. Let's just do a source book and still do the hyperlinks. So we developed the source book, and in a period of about 3 months, because that was in July when we trained the justices of the regional court, and in October when we were training the local judges of Uganda in Kampala, we said, okay, here is the source book. And remember, Justice Kiriabwire is the one who launched it on behalf of the court. And so this time around, when we were starting the training of lawyers, ahead of the training, we said, let's update the source book. Because much had happened between 2021 October and at the time we were developing it in 2022. So we actually incorporated the 2022 decisions up to November. And then waited, when we even were the draft, we waited up to the session of the court in February 2023 to see if there were new decisions out. So there weren't many new on good governance and the rule of law. So we then said, let's print ahead of the first training in Dar es Salaam in May. So look at that source book. We may not give you hard copies, but we're going to give you the digital copy. And as I said, PDF, but each time you put your cursor anywhere near a case, it will show you the thing and allows you to click and access to. And what I've done is to make sure that you land on the website where the case is first reported. So you not land on the PDF of the case. Why I want you to land on that page, that then you can see for that decision, there might be applications, there might be, because what the court has done for each case, they sort of give you, whether if this is the first division, if you scroll down on that, there's an appeal. And if there's an appeal and pending, then you want to see that, but to tell you that this matter has been appealed against, it's been probably waiting. If there's already a decision on appeal, then you can see it also. For those who might want to read further. So sometimes if it is appellate division, you still land on that same page, and then you can say, hey, but there's an original decision. So that's the source book. Then yesterday we also looked at, in the afternoon, how do you engage the EACJ, and we pointed out the first thing, pay attention, the court's jurisdiction. So don't just rush that because the client has come to you, get excited, my first opportunity to go to litigate before the court. Pay attention to the jurisdiction. Is this the matter that the court should have jurisdiction? Is the client asking you to, is the client making an argument that the action taken by partner state is an infringement of the what? Of the treaty. The rationale material. Can we showcase that the treaty is being infringed by the actions taken by a partner state? Can we attribute an act of an agency, a department of the partner state to the partner state? So for instance, in that problem question, if you ignored the national court, would we still go to the regional court? This is the National Bureau of Standards. So there are those questions you ask. But it's the same things. That's just like the way you attribute every behavior of the government officials to the Attorney General of Uganda. So you don't sue the Minister of Energy. That happens in South Africa, by the way, and the US. You sue the respective ministry. You don't sue the the Attorney General. But that's because that's what the law allows them to do. So likewise, every conduct that you can see can be attributed to the government. Or you can show that its actions can be attributed to the government's failure to comply or adhere with the treaty. Then you sue the Attorney General. In a matter that we handled, we had two parties that we were trying to tie. And they tried for years, even on appeal, to argue that that's not the responsibility of the government of Rwanda. There was a commission on abandoned property set up by law. The argument was that we are independent of the government. Our actions cannot be attributed. That's what the Attorney General of Rwanda was arguing, that the actions of the Commission on Abandoned Properties cannot be attributed to us. Then the next act was the Revenue Authority. Rwanda Revenue Authority. They have tried to argue that those also are, but the court agreed with us that some of these agencies that are created by the state, their actions, if we can show that they are in violation of the treaty, are attributable to the partner state. So you need to that. So that will be part of jurisdiction. You must show that link, that the acts of an agency can be attributed to a partner state. If you can't demonstrate that link, then there's no need to go to the national court. I mean the regional court. That's part of ratione persona. That the partner state, remember we mentioned that list that is, they are only the proper respondents at the partner state, not its agencies, not its officials, the partner state itself, and then the community, institutions and organs. And then remember the 6 months, 60 days, 2 months rule. Again, make sure that you determine when the client become aware of the action that is being challenged. That's tied to admissibility. Legal standing, we already covered that, the applicants and respondents. As applicant, we pointed out that you need to make sure that your client, as an applicant, is a resident of the EAC. For now, that has been critical. So just if your client is residing in the US and been residing in the US for the last 20 years, it might be difficult. So then you need to discuss with your client what's the vehicle for the claim. If your client has investment in East Africa, you may be able to demonstrate residence by the fact that those businesses are established in the East African community. And therefore, the vehicle is not the individual, the legal person, the natural person, but the legal person. So if the person is running these businesses by way of a company, by way of a business name, then those are the ones which become the applicants. And then you must adduce evidence, certificate of incorporation, a certificate of registration, and the like. And as I said, it's the entity, not the shareholders. Because remember, if for instance, a partner state is trying to expropriate, take over the company and its shares, the shareholders are there, but it's the company which is the victim. So just think of how we do national law. Who sues? And then we discussed appearance, representation, advocates. As long as you are licensed to practice, you have a valid practicing certificate that you can file with the registry, the sub-registry of the court in a partner state, then you are good to go. You have the right to appear and represent before the court. The issue of license doesn't really come up with the Attorney General of the partner states, because usually the assumption is that if you turn up and you say you are a state attorney from the partner state representing the Attorney General, just as we do with national courts, nobody disputes that. Nobody disputes that designate. We all know what the state attorney is from the Directorate of Civil Litigation. So you're not going to raise up and say, Your Lordship, a council doesn't have a PC. I don't know. For a long time, they never wanted to get PCs. Now, I think that the fact that you need to show that you are have a right to appear before court, so now they're beginning to push to get PCs on a regular basis. Because, judgeship, people ask, so what is your practice for and you have been appearing on behalf of the AG. But I still believe they can get the requirement. I think just People are panicking for no reason. But eventually, when you get out of AG's chambers, as most people do, you find it that difficult to show track record without pieces. Pleadings, as I said, just as we do pleadings in national legal system, we need pleadings. You cannot engage the court without pleadings. So you must file a statement of reference or a statement of claim. And then the defense must put in their defense. You need the procedure for amendment of pleadings. There's preliminary objections that can be raised. As I mentioned, this usually turn on jurisdiction, but it also, there are other preliminary objections you can raise. You can raise regarding the affidavits that support the reference, just like we raise preliminary objections arising from pleadings, that the pleadings don't meet the requirements under the civil procedure rules and all that. If someone brings an application for amendment of pleadings, you can still raise the preliminary objection that amendment falls foul of the procedural rules, the East African Court of Justice procedure, where in regards to amendments. Remember, the amendments you can make before without leave of court, and then the amendments which require leave of court. Third parties, I mentioned this. So when you, as I said, if you get cases and you keep seeing the respondent doesn't look like Attorney General of a partner state, know that means you are dealing with amicus or interventions. We didn't get this in detail, but look at the litigator's manual. It details for you what you need for amicus. We actually, when we were doing the amicus rules for Uganda, because we had no jurisprudence beyond Loko Nyango, when they intervened in the election petition, I think of Amama Mbabazi, there was really no jurisprudence. So even drafting the rules was sort of shaped by what we could find practice elsewhere. But importantly, what has happened before the East African community, those things that you must show that you are bringing expertise. You're not just someone who wants to come in. You must demonstrate that you're bringing a certain level of expertise that the court needs to have as a friend of the court, because that's what you are. You're a friend of the court. That's what amicus mean. You are not taking sides. So you are coming to offer balanced, expert-based opinion that will help the court make a decision. So there will be that issue of impartiality. And the jurisprudence of the court is rich on each of those principles. And the idea is that sometimes even when you come as an expert, it does not necessarily mean that you don't have a certain view. Recently, we got a decision out of the Constitutional Court where they threw out one of our amicus. They said the expert whom we are trying to bring can't be impartial. What do you expect the UN Special Rapporteur on freedom of expression is going to say? He's going to tell you this is what the principles of freedom of expression under the international instruments are. The government may not like it, but is a set. So I don't know what the court was thinking, that it was supposed to come and what? Speak on behalf of the government. Anyway, let me ask you, if anybody thought, what is the freedom of expression under our constitution? You're going to say it basically means you are right to freely say whatever you want, even if it's annoying to everybody else. The government will say, no, we have limits. But that's not what you are supposed to. You are trying to explain what freedom of expression means. Of course, it means that you can also have that view that it doesn't mean that you can go and begin abusing people. And that will then you'll find yourself falling into the law of defamation and the like. Anyway, so you'll get the principles set out, and but one of the things that you need to know that you don't just stand up and say, we want to be a friend of the court. You must make an application. And all the applications that are not the statement of reference or claim are by notes of motion. Good thing they you. Sometimes they even refer to a template, a form in the rules, in the appendix to the rules. So just when you get the rules, watch out what the rules are providing. If they are referring to a form, to that form. and use it, just like our civil procedure rules. Go to that form and use that form to develop the. But sometimes if it is silent, just say notes of motion. Just remember we do notes of motion. It's not different. Remember, most of these, by the time the court was set up, the bulk of the partner states and the likely lawyers were common law. So we know how our notes of motions are drafted. As I told you, and Rwanda lawyers didn't understand affidavits. So for them, that was alien. So that's why they have sometimes a difficulty. Something with interveners, you just don't turn up. There's an application. Now, there are very specific guidelines there. The reasons for you must be set out in the application. You can't file a different affidavit for that. It has to be an application. So the good thing in those guidelines, the court has developed those in the jurisprudence you have in the litigators. So as I said, for these purposes, things like scheduling conference, hearing, interim measures, temporary injunctions, and all that, that's the detail of the practice. Now, all these, the resource text is the litigator's manual, litigating before the East African Court of Justice. Again, there's a digital version. When you get your materials on the flash, you actually have the old folder, so you won't get lost. Okay, let me look for which is. Just click the folders, and in the folders, the manual is also hyperlinked to the court's website. As we go through let's be attentive that this is an opportunity not just to learn a new area of the law. Some of you are probably already thinking about it, but also an area where you can explore legal practice beyond the good governance and the rule of law issues. Some of you are typical public policy litigators, public interest. This is your, what I call it, bread and butter, but others might think our bread and butter is more on the trade side. Again, as I said, opportunities to self-learn and expand your not only knowledge, but also areas of practice. So thank you, that's the recap. And so Mr. Gimara, Senior Counsel, will take over. I think you already have the questions from exercise from yesterday. So that's what we are moving to next.
Okay, maybe just a round of applause for Dr. Honoria. I know that he has put in a lot of hours. When you get the litigator's manual and the source book, when you eventually make use of them, that's when you will know the amount of time and skill that has been deployed to have them produced. This morning, I am just going to get us a bit practical in terms of how do we as lawyers practicing in this jurisdiction engage the EACJ, and what, in addition to the causes of action that we, evolve, what in addition can we begin to deploy in our pleadings that is informed by the community law that we have been unpacking from yesterday. And the way to do it, we want to make it very practical. We will go through the exercise. Every lawyer can know the law, but the problem can always be how do you deploy the law within or on the set of facts that you have, isn't it? And that is what we want to do in the next couple of 1 or so hours. But to start us off, we had a problem yesterday. Who would like, it's going to be a very practical discussion, okay? I am just going to facilitate a conversation. And would like to start with who has understood the facts very well from yesterday and would like to share with us. Yes? Doctor, help me with that microphone. Who wants to have a go at the facts? You remember in LDC we used to start with what are the brief facts before we dug into anything. So that's definitely not a new question. We have heard it. Yes, my friend, have a go at it.
Good morning, everybody. Briefly, the facts, maybe I can start by saying it's a current practical issue that is happening, I think, in the South Sudan. Even there was an update last night. Anybody who watched the news on NTV, there was some update on the same issue. I hope it is South Sudan. Then
maybe not. Assumedly not.
Okay.
Let's deal with the facts.
The facts here.
Yes.
The facts are you have a company which is doing business and it has decided to do regional trade from one country to another, and they have specific goods that they are trading in. They take the goods to the other country. On reaching the country, as always, you go through the border crossing. The officials, unfortunately, they say, hold on, let's first, they first withhold the goods. And upon withholding the goods, this guy is trying to investigate to know why. He doesn't at first know why, but he's told that first go to the ministry and you check. Now, on a closer follow-up, he realizes that there are some guidelines that were published which were declaring the goods not fit. Okay, not fit might not be the right word, but beyond the level of what is acceptable in the components in the products. Maybe the moisture and aflatoxin, especially for maize and the rest. Now, on following up, he realizes that he has hit a dead end. And all of a sudden, he's told that he has to re-export because those goods are no longer allowed in that country, primarily because they are above the level acceptable, and there's standards which are currently being used, and the goods are not passing that test. So he's told to export. A decision I think he's not comfortable with. He's like, let me seek legal redress.
Thank you.
Thank you.
That's a very good attempt. Indeed, a round of applause for him. Who wants to have another go? Yes.
All right. Thank you. The brief facts are that we have a company called Noitan Enterprises. It's a company, a private limited company, registered in Adnagu State. And Adnagu State is a partner state of the East African Community. The company deals in importation and of cereals and other food commodities, and it imports this from other partner states. So, based on a notice that was issued by Adnagu, the company applied for and was granted a license to import 125 tons of cereals. This included rice and other crops. And however, when they tried to import it into the country after paying all the required taxes, they were stopped, and this was based on certain circulars that were written by the Adnagu state officials. They were advised that the cereals do not meet the required standards, and they were supposed to re-export or the cereals would be destroyed. The companies agreed, and they intend to file a matter in the High Court.
Very good. Another round of applause. One lady, and then we will, this time a lady. We have to balance these things. We are very sensitive to Eh?
Very good morning to you all. I think I'll re-summarize what my two colleagues have summarized. There is a company, they export and import cereals, and their goods have been impounded, and now they seek legal redress from the High Court.
Thank you. Thank you. Let's start unpacking this problem as a typical let's pick out again from what the three presenters have shared. What are the pertinent facts? You know what they call legally relevant facts. Not all facts are important. For lawyers, you must always listen to the client. Sometimes you have gone to a client, if you find one who talks a lot, you can even get headache. Yeah, so you can listen for 30 minutes and you pick only one legally relevant fact. Another 1 hour, you pick a what? Another legally relevant fact. Then you'll find others who will go straight to the point. So in a typical legal problem, what are the legally relevant facts for us? Okay? Remember what we are doing. We are trying the end result. We are advocates with free trade lawyers. We have a license to practice before the High Court of Adanago, and there are issues that are going to come at conferencing. That's where we are, okay? If that's the end picture, the relevant facts then for us are correct. There is a company. Remember, we start from yesterday, who can sue in these matters? It's a very important question. Eh? There is a private limited company incorporated in the Republic of Adanago, a partner state. That's a very relevant what? Fact. Because you see, if it is EAC law and it's not a partner state, you will be challenged. Okay? So that's important. And we see that it was admitted. Maybe we'll jump that. Then it's engaged in business. Cereals, importation, we will move. Maybe go to the second paragraph. There is now an opportunity, January 2023. The Trade Minister of Adanago issues a notice granting a waiver of import duty on 900,000 metric tons of assorted grains and cereals to be imported on or before 30th. This notice is published. We go on, and then we move on. What then happens? We see that there's something begins to, the company sees this opportunity, it wants to take benefit. Typical commercial transaction, right? And we go on, we now see they participate, then they begin to move trucks. 22 cargo trucks arrive at the border customs, awaiting to convey the goods into the territory. And then what happens? The goods are seized. You get it? The goods are seized. And the problem there is they have paid. They have paid the requisite transit taxes. Then they write to the Commissioner Customs and Excise at the Republic of Adanago. No response. Okay? We will come back to that. Although the officials say verbally, ask them to verbally check with the Ministry of Trade. Then this is where now a legally relevant fact as a lawyer. A trade promotion officer draws their attention to a circular titled Non-Entry of Food Products. Dated, the dates are important, right? Dated what? May 19th, 2023. Remember that it was issued. That means it was processed. That circular came during the transaction, isn't it? Okay. We will come back to that. The circular has an effect. Okay? It directs unlisted foods, in particular grain and cereals, from a specified partner state are not allowed. Okay? Is that a material fact? Good. The circular is issued, next page, on the basis of National Standards Bureau Act. That's also important, isn't it? Upon further diligent efforts, the company officials discovered that on May 19th, the ANSB issued a declaration of compulsory standards, again during the process, right? Gazette notice number this specifying ADNAGU standards for food and agriculture. Under the Act, remember there's a circular, but there's also now a law, right? Under the 2019 Act, ADNAGU standard means a standard produced or adopted by the ANSB for use in ADNAGU. On the basis of this, Gazette Notice 2488, 2023 and May 19, 2023 circular, the ANSB has directed on the basis of what? That Gazette and the circular. Remember, relevant facts, relevant dates. We now have a decision that is potentially problematic for the enterprises, directing that the 125,000 tons of food products imported by Noitan Enterprises be re-exported to the country of origin or destroyed. Then when are they notified?
June 12th.
Very good. To re-export goods by when?
By July 15th.
Or what will happen?
They shall be destroyed.
They shall be destroyed. They feel aggrieved since the pre-packed grain and cereals have certificate of conformity of standards issued by partner states from which they were sourced. You get it? They are, remember again, regional law. Standards from a partner state, what is the implication of that to another country? Can a country come up with a standard without compliance to the legal framework at the regional level? Those are important issues to be alive to. Now, procedurally, Noitan instituted civil proceedings before the High Court, claiming the seizure was unlawful. Ordinarily, many lawyers, maybe even you when you came here, you would think that this is a regional integration matter that must go to Arusha, isn't it? Isn't it? But now it is in High Court. And yesterday your questions in the evening were around this. You know? Why National Court when it is a matter of regional, a matter of regional integration, that is the jurisdiction of EACJ, isn't it? But we'll see whether these companies is wrong in a short while. In its pleading, they state that action of ANSB in issuing the May 19 circular and Gazette infringes the East African Community Management Act as amended. As regards what? Power and procedure. They again plead that, so ordinarily that is the commercial challenge that you are, initiating. But you see that in addition, they are pleading that the issuance of the circular notice is an affront to the principles of good governance and rule of law under Article 6D and 7.2 of the Treaty on the Establishment of EAC Community, as well as the free movement of goods and obligations on harmonizing and mutually recognizing certain trade standards. The Attorney General typically has filed, and the matter is for conferencing. Okay? So many things, commercial matter, rule of law issue, fundamental principles that underpin the community, operational principles that underpin the community are under interrogation by this problem. So the question today is, if you're a lawyer with this problem and somebody tried to share with us what's happening in South Sudan, maybe these facts are similar, maybe not. But suppose you have a similar situation. What are you going to do as a lawyer? When do you go to regional court, and for what? Must you go to the regional court automatically on the basis of this? Must you? We'll find out. If not, why? Why? Why shouldn't you file at the regional court? And why should you file at the national court? That's something also we want to unpack. So before we unpack, let us get back to the groups to tell us how they responded to these issues, and then we will start from there. So we start with Group A. Group A, is this Group A? A. Who is the spokeswoman or spokesman? Who? Did you appoint? So can you appoint now? So I leave the microphone here so you decide between two of you.
So I'm speaking. So we are going to who may sue?
Who may sue, and what are the possible?
And the elements of
Okay, let me start and then you continue.
Okay.
We looked at one, whether this matter is directly to the regional or the local courts. But what we realized that was an act that might be complained about is the Customs Management Act. And if it's the Customs Management Act and the act complained about, which brought about all these issues, is seizure of his goods, which is under the Customs Management Act. So we said, yes, he has a cause of action, and the case is fit for the High Court in Adinagu to begin with, because of the management of the East African Customs Management Act.
Then we also, in looking at the issue of jurisdiction, we looked, as we were told yesterday, in deciding should we file at the National Court or the East African Court of Justice. We looked at the elements of jurisdiction, such as who may take the case to the East African Court, issues of jurisdiction, rationale, personnel. Is it an organ of the East African? Is it an organ of the East African? Is it an organ of the EAC? Is it a partner state? Is it an institution? Like yesterday, we looked at institutions of the EAC, like the Intergovernmental University. Yeah? Then we also considered the issue of matters to do with the Common Market Protocol. There is a provision that says that the EACJ, Article 34 of the treaty, says that the EACJ shall never entertain matters related to the Common Market Protocol. That unless it's an interpretation question, they should be handled by the local courts. So that gave us an avenue to know that the matter is filed in a proper court. Yeah. And then the fact that even the parties that we are taking to court are not EAC institutions. These are, our local institutions here. I mean, the Adangu institutions, the Revenue Authority, the Standards Bureau. So we knew that the matter is filed in a proper court. Yeah.
Thank you. That's good. Quick comments. Maybe let's do group B, C, and D, and then do quick comments. We grab T and then return for discussion. Group B.
Thank you, Senior Counsel Kimara. Pertaining to Group D, we observed carefully that we needed to determine two issues. One, whether this is a matter of interpretation of the EAC treaty, and then two, whether this is a matter of enforcement of the existing law. And we grounded that this is a matter of enforcement, and like our sister said, it's a common market protocol matter, and we strongly believe that this matter is filed in the competent court of jurisdiction of the National Court of Adnam. Thank you.
Thank you. Round of applause for the group. Again, we'll discuss enforcement and interpretation. Who does what and when? Okay. Group C.
Thank you. In regards to Group C, ours was in regards to a preliminary ruling whether the High Court should seek a preliminary ruling of the East African Court of Justice on alleged infringement of Section Article 6D and Article 7.2 of the EAC Treaty. Now, in resolving this issue, we looked at the treaty of the East African Community Treaty, and specifically we looked at the jurisdiction under Section 27 that gives the jurisdiction of interpretation of the treaty to the East African Community Court of Justice, East African Court of Justice. We also looked at Article 34 on preliminary rulings that gives the mandate to national courts of partner states to refer a question for interpretation to the East African Court of Justice. Now, our reading of Article 34 seems to point out that the issue of seeking a preliminary ruling is based at the discretion of the national court. We've, as Group C, further read and came out and visited some cases. Specifically, we are looking at the case of the Attorney General of Uganda, Republic of Uganda versus, I forget the other name. Let me just get it here. Yes, Attorney General of Uganda versus Tony Charuenda. This is case study number 1, in which the issue of preliminary rulings were discussed, and the key takeaway from the decision is that much as the East African Court of Justice has the exclusive jurisdiction in regards to interpretation of the treaty, national courts also have that mandate. So the national court can either choose to refer a matter for a preliminary ruling, and it can only do so if it touches to the fundamentals of the treaty of Section 6D and Section 7.2. So, in conclusion, we arrived at the decision that yes, the High Court, it has a discretion. It can either refer or not. And in these circumstances, I believe the High Court will not refer because it has jurisdiction. And where there's a decision already in that regards, then the decision of the East African Court of Justice takes precedence over that of the National Court. That was Group C.
Thank you. We will return to discretion. The key word is discretion. When do you exercise that discretion, or when do you as an advocate invoke the court to exercise the discretion to refer or not to refer? Very, very important. We will return to that. Group D.
Thank you so much, Senior Counsel. Ours was, I think, the simplest. We have been guided already by the rest of the discussions. On the procedure we undertake in the High Court to make a preliminary ruling reference to the East African Court of Justice. In this, as we're reading through, we first went to Article 34. We also went further to the EACJ rules. And our domestic law is when a matter is in court, usually all applications we make, preliminary applications by notice of motion, supported by an affidavit. So that's how we would trigger the court to hear our concern of making a reference to the EACJ. And this it would be an affidavit, a notice of motion supported by an affidavit. And in this, we quote the usual sections, Section 98 of the CPA, Order 52 of the CPR, and we also quote Article 34 of the EACJ Treaty. Yes, that was the brief.
Thank you. Thank you. A round of applause for all the groups. Quick comments, questions. We can now respond generally to all the groups. If you have a comment.
Thank you so much. Maybe just to add on, when you look at the guidelines that are on the ECJ website, it tells you when you're making a reference in terms of the preliminary ruling, you must be concise, it must be clear, it shouldn't be more than 10 pages. It should have the brief facts of the case, what are the arguments of the parties. Then it should also state, if at all the judge has an opinion on the matter in terms of interpretation, he can go ahead and give his opinion on the same. Yeah.
Thank you for that intervention.
I just wanted to add one thing that pursuant to the East African, coming in force of the East African Common Market Protocol, an act was created called the East African Standards Quality Assurance and Metrology and Testing Act. Now, under that act, Section 24(2) of the same act provides for East African partner states to have quality marks and recognize them as equal to their own, which will facilitate free movement of certified products within the region.
Thank you. More research, more laws. Important, always dig in. Yes.
My comment is on Group D's reference to the Ugandan law, yet the problem question is another country altogether.
Okay, we'll return to that.
All right, thank you. Mine is also a question in respect to Group D and probably generally the entire members here. Can the court, the National Court at its own instance or motion, seek a preliminary ruling from the EACJ, or there must be an application?
The guidelines say the court on its own motion or without the parties' intervention, they can go ahead and refer. The court can refer or the parties can refer.
The court where necessary.
Okay. Now, I'm seeing some bit of confusion. There are two instances. There is the court, which is the EACJ. in Arusha. And there is the court, which is in Adnagu. Adnagu. I used Ugandan law because I don't know Adnagu's law properly. So, the question here is telling us how do we trigger the court to make a reference to Arusha? That's it in brief. So actually, the EACJ rules on the procedure of how the court conducts the preliminary ruling references, those apply to the court in Arusha only. It doesn't apply this side. So that's what I wanted to make clarity. We have our domestic law this side.
Thank you. We'll return to that. Any other question? That one will come back to it. If something new, is it the same?
I was going to slightly disagree with him. The guidelines, the reference for preliminary ruling guidelines on the site of the EACJ talks about local courts, domestic courts within the partner states making the reference. So it does not matter which partner state it is, as long as it is a court within that state, that court can make a reference.
Good. So thank you so much. What we will do now, I don't want to interrupt the session of responding to this when we start. Let's take off. How many minutes is the break? 15? 15 to 20 at most. Have a health break. Grab some tea or coffee, and then you return and we interrogate this problem, right? Okay, thanks.
East African Court, and I think the East African Court contacts the parties.
normally arise from problems in appreciation of the law by council. So at least when we live here, we'll have at least assured one thing, that any council who has attended this training will never be condemned in costs. Of course, we don't guarantee that you will win the matter, but at least we guarantee that you will never be personally condemned in costs. Yes? So that's the first guarantee, but let's see. So there is what we need to establish, two things. Article 27, jurisdiction of the court. We have looked at that. The jurisdiction of the court, East African Court of Justice, initially interpretation and application of the treaty. But then the proviso says, under this paragraph, the court's jurisdiction to interpret shall not include the application of such interpretation to jurisdiction conferred by the treaty on the organs of partner states. Then 33 also talks about jurisdiction, but also says, emphasizes that the national court also has jurisdiction. Then 33.2, decisions of the court on interpretation and application of this treaty shall have precedence over decisions of national court on similar matters. So when you look at those, you could easily arrive at the place that national courts also have jurisdiction to interpret, right? But we will see. Let's move on. But 34, this is the master article for us to unpack this morning. Article 34. That is the fulcrum of the relationship between national courts and the EACJ. And I'll read it. Where a question is raised before any court or tribunal, you can even see that tribunals are brought into the picture, of a partner state concerning the interpretation or application of the provisions of this treaty, or the validity of the regulations, directives, decisions, or organs of the community, that court or tribunal shall, what does shall mean? Must. All times, without exception. Legal drafting. We will come back to that. If it considers that a ruling, if it considers, underline that, if it considers, would you now say that it is still a must? Okay, we are together. So far, so good. If it considers that a ruling on the question is necessary, underline the word necessary. To enable it to give judgment, request the court to give a preliminary ruling on the question. So reading at 34, looking at 34, looking at 27.1, together with 33, 2 points come out. One is that the jurisdiction of the national courts is recognized under Article 33 of the treaty. Of course, subject to 27 and 34. Another point comes out for us to note very early in our discussion this morning. Discretion. Okay, good. We'll come back to that. But we must also note something that was asked yesterday. That now from the problem we have, the point that we must take away is that community law broadly, like Dr. laid out, okay? Acts of Parliament, protocols, directives, etc., can be invoked and enforced before national courts. You remember the point? What we are saying that those community law now can be invoked before national court. And the EACJ dealt with that matter in East African Law Society versus Secretary General of the East African Community, reference number 1 of 2021, that you can invoke those matters in your national courts community law. And that is why the design of this problem has an element of community law. It's in the High Court of where? Adnago. Okay? We are now saying you can actually invoke what? Community law in that High Court, isn't it? Then the reason here is that the national courts are really supplemental to EACJ. Okay? 23, 27. But importantly, why national courts are critical is that there are matters that if we only waited for regional courts, they will be very difficult to prosecute in time. You get it? But of course, when you're dealing with this matter, I'd like you to have time to read and read Charuhenda again, because it is well reasoned on the interrelation between national courts and the regional court, the EACJ. And the issue there, main issue was whether the provisions of Article 6, 7, 8, and 123 read together with Articles 27 and 23 are justiciable in the national courts of partner states. Now, the court says, first of all, Article 27 is very broad, and it gives a broad and general jurisdiction of the court. But importantly, the court says there is nothing in that article which purports to grant a monopoly of interpretation jurisdiction to the EACJ, like we said, when you read them plainly, at the exclusion of any other entity, including national courts. Like I said, on the face of it, it appears to suggest that both national courts and EACJ do indeed possess the jurisdiction to interpret and apply the treaty. But that is not entirely the point. Because the court goes on to say, yes, when you read the article on the face of it, that is what happens. Now, in this case of Noitan Enterprises, we are trying then to look at, in a practical scenario, when should the national court come in? When should the EACJ come in? And what does Article 34 mean? What about 27 and 33 that, in a way mention national courts? And that's where the problem can come in, because you can rush saying, national courts can easily interpret. But if you haven't read Charuhenda, which really clarified this, you would be lost, in a real way. Because when you look at this problem, the key thing then for us to always remember when you are dealing with these problems like this, what is the cause of action? Is it under the ESC treaty or protocol? That's always an important issue for you to ask. Okay? What is the cause of action? And you locate for a cause of action on the basis of community what? Law. And the other thing that comes, should the High Court here and determine the claim on the basis of infringement of Article 6D and 7.2 of the ESC Treaty and the Common Market Protocol? Should the High Court determine the claim? Now, if the High Court has to determine the claim, should they, in determining the claim, consider requesting a preliminary ruling of the East African Court of Justice? And if they so consider that it is necessary, what is the procedure? Those, for me, are the things you will always engage with in a domestic setting while dealing with matters of EAC. We get it? Cause of action. Okay? Should the High Court hear and determine on the basis of the treaty thing, or it is a matter that the High Court should request for a preliminary ruling? And if the High Court determines that they need to request a preliminary ruling, what then is the procedure? If we sort this out, then that thing we started with, you will never be condemned in costs. Okay? You have survived that trap forever. They may disagree with you, the court, which is normal. Though sometimes these young lawyers, when the court disagrees with you, they take it personal. They want to even remove a court and box both the judge and the lawyer on the other side. Don't be personal on these matters. There are days you have a good day, there are days you have a bad day. It's normal. Okay? But nowadays, litigation is personal. The lawyer is personal. He has owned the client. Even the judge is personal. We need to relax. We need to enjoy practice. Understand on a good day you can lose. And also understand that you can appeal. You don't have to, be angry and throw everything. Okay? So, let's proceed. Now, let's go back to our problem. Let's look at the facts again. Seizure of goods of Northern Enterprises, okay, on basis of a circular, okay? And we also see this letter in terms of process received on June 12th, okay? To the export by July 15th, or they will be destroyed. Which law deals with powers and procedures of seizure of goods? Custom goods. From yesterday. Which law? Cite it in full. So when you are dealing with seizure of goods, it's governed by the Customs Act. That is the law. So you have to interrogate your facts whether that law was followed. You get it? And we'll return to the effect of not following an act of parliament where you are supposed to follow. Okay? Then, conformity with standards also. That was another issue. There is a general framework for dealing with standards. Okay, was that follow? So can you seize today under the regional framework? Can you seize goods by circular when there is an act of parliament? Okay? Those are now questions you have to unpack. Okay? So when we unpack this, we arrive at two things. One, the absence of procedural due process. You get it? In the seizure of good. And procedural due process is very, very important. It's a rule of law issue. When you don't follow procedure laid down, you have violated the rule of law principle. Because part of rule of law is following due process, isn't it? And in that case, Grand Lax Supplier, SAL, versus Attorney General of Burundi, reference number 6, 2016. In that case, when you read it, you'll find that, again, the government of Burundi, through excessive actions, some of its civil servants seized goods without following procedure. The court held that seizure of applicants' goods without due process violated rule of law stipulated in Article 6D and 7.2 of the treaty. Please remember the cause of action is violation of those principles. You get it? 6.2 and 7, those are the majority of the cases before the East African Court. And the East African Court of Justice, as in numerous cases, held that you cannot build a functional East African community that does not respect those principles. Said we are coming together as a community, but the principles in Article 6, in 7, are very important for us to build a community. So it is a requirement that partner states oblige to fundamental and operational principles enshrined in the treaty. So ordinarily, on this case, you can just say under the East African Customs Management Act, due process was not followed, you will be dry and home, right? But you can also say, in addition to violating this act, the treaty, Article 6, okay, 6D and 7.2 of the treaty was violated. And in that case, they have clearly stipulated that that amounts to violation of the treaty, okay? Then, the second premise for the cause of action in these facts has to do with standards, non-compliance with your own national laws. You get it? You enact a law as Uganda, you don't comply with it. The EACJ has held your non-compliance with your own domestic laws amounts to violation of those treaty articles. So two things there. There is an act, due process, you've messed up. Also, you have a law which you're abandoning and creating a circular. That also can be impeached in a proceeding, in a legal proceeding on that basis. So we are now calling on you to be watchmen and watchwomen on two fronts. Due process, are the public officials exercising due process? If not, how do you deal with them under the EAC framework? The second issue is if the national law of that particular country provides that on this matter, this is how you must handle it, and you don't, then there's a problem. A case in point is Henry Chalimpa versus Attorney General. That case was filed at the EACJ. And Henry Chalimpa was challenging the procurement process around the dam at Karuma. His cause of action was premised on the fact that Uganda had a legal regime for handling procurement. But in that case, the government abandoned that legal framework and selected Sinohydro to build Karuma Dam. So his cause of action was the act of abandoning your national procurement law, your national law. Remember, he's not challenging the PPD Act because that jurisdiction would be internal. He has to start with PPDA, then he comes to us to PPDA appeals tribunal. If you went to court and you challenge that, you will go back to that problem we said earlier, you would be condemned personally in court, because the court will say that but you are really, there is a PPDA Act, why didn't you challenge? Please don't make that mistake, okay? Don't go and plead PPDA Act was violated, this or this, then it will take you to the procedure in PPDA Act. But be very ingenious, get your cause of action around the treaty. Look at the treaty and say, what action does this violate versus the treaty? You get it? That is the issue with EACJ law. The ability for you to frame your cause of action based on the treaty. You get it? If Chalimpa had gone and framed it based on the PPDA law, they will tell you go back home. You get it? But he framed it in terms of violation of the treaty. That's a rule of law issue, actually. You have a law, you don't follow it. Best rule of law issue. You have made a commitment by being a member of East African Community that the rule of law will be very important. Meaning that if a country's parliament passes a law, then they must follow that law. If they don't, then that's a rule of law violation. Yes? So in Henry Chalimpa, that's what happened. Let's get a question or comment. Yes.
Thank you, Senior Counsel. Me, I've been grappling with a question of a country not following its own laws, but then in a way where that non-compliance is sanctioned by that country's courts. We have so many instances where courts have made clearly what I would call per incuriam decisions outside of the law.
Yes.
You have a law.
Yes.
Someone goes to court. Court says, no, there is no non-compliance, when clearly there is non-compliance.
Yes.
I'll give you an example, maybe 2 examples. I think there was someone challenged the oil procurement, and then the court said, but this is okay, everything was done okay, when clearly they were not. And then, of course, I think also someone from Makere challenged the judicial appointment of judges on in acting capacity, which clearly violates the Constitution. The Constitutional Court said, yes, this violates the Constitution. Attorney General appealed, filed a notice of appeal, got a stay of execution from a single judge of the Supreme Court, and immediately appointed another round of judicial officers in acting capacity. And that's likely, let's assume this appeal is not heard for the next 10 years, which is a possibility. So there will continue being a clear violation of the Constitution, sanctioned by the highest court because there is a stay of execution of the judgment of the Constitutional Court. So can you still go to the EACJ and say there is a clear violation of the law, there is non-compliance with the law, when there is a court sanctioning that non-compliance?
That will get there shortly. Let's look at, I'll jump Grand Sachs. Let's answer your question by looking at what happened in Martha Wangari Karua versus Attorney General. In that case, the Supreme Court had resolved the matter. Okay? Martha Karua took the Republic of Kenya. Again, you don't sue the Supreme Court. The respondents are clear in these matters. Again, avoid being condemned personally in courts. By suing a wrong party, you may have the best case, but the choice of parties is very important, right? In Martha Karua, they looked at the Supreme Court decision, and the way they phrased it, and you should read that, it will help you in details. The court said that the way the Supreme Court handled that matter violated Martha Karua's right of access to justice and fair trial. So you again see it wasn't an appeal from appealing the decision of the Supreme Court. You get it? You cannot appeal a decision of the Constitutional Court or High Court using these proceedings. But in Martha Karua, if you say the way this court conducted itself, they violated my right of access to justice, and by extension, violated rule of law, then you file. You'll be dry and home. If you went via direct appeal, you will fall on day one. Okay? So Martha Karua will help you to digress that. But then, of course, you'll get declarations and all those things. But if you find that a court has really conducted itself in a manner that is unbelievable, if you use that word, and is becoming very increasingly possible in Uganda. But we are all guilty. We even ask the lawyers. The other side is celebrating the court. This side is celebrating. Because it's essentially sometimes lawyering has become so personal as it is a do or die, you know? So we are partly responsible for the state in which we are, but I hope we can. Part of this training is for us to open up mechanisms, okay, of promoting good governance and rule of law using the broader architecture of the EACJ. But that matter, Martha Karua can sort you out. Remember, phrase it as a treaty violation, okay? And then move with the authorities, it will be sorted. Okay? Clear? Are we clear on that? So far, so good. Any questions? Any questions? Comments? Because this is, so generally when you look at the decisions that we have got to look at, Martha Karua, there is Rugamba, and then quite a number of cases where many things have been, where the court has been very, very instructive on many of these. And I'll just share a few of them. Then, of course, also under those facts, you will notice that there were common market protocol breaches. You get it? And the question, if it is a common market protocol breach, where do you go? Again, this is where you have to be very, very, very understanding of the procedure. Now, of course, there are parallel places where you can do that. But importantly, relating to common market freedoms, the preference, even when EACJ has power, and indeed they have said on several cases, there's a group that says since it's a common market protocol, probably it should be heard. It should be heard in EACJ in some of the discussions yesterday. But yes, EACJ can look at generally violation of common market freedoms and deal with it. A case in point is Samuel Mukira Muhochi versus Attorney General of Republic of Uganda. Any one of you remembers that case, where Samuel was flying into Entebbe and he was declared a persona non grata on arrival. He was picked up, detained. You know, they had come, he was part of the delegation that had come to see the Chief Justice, you know, to have a discussion about some of the people who had been arrested. So he was off-boarded and then not allowed to come to Kampala, detained, put on the next Kechu flight in the evening and sent back to Nairobi. Samuel went to EACJ and said, well, the way the government of Uganda conducted itself in arresting me, detaining me, violated the treaty freedoms, you know, common, the 4 freedoms. And the court said failure on the part of the partner state to follow its own immigration laws, because even then, the immigration laws, as you know, has a procedure. Eh? If you have to do that, you take somebody through a procedure. So again, you see a case of failure to follow your own internal laws. So the court was saying the failure on part of a partner state to follow its own immigration laws in declaring an applicant prohibited immigrant was in breach of the rule of law under the treaty. Okay? So from these facts already, I can tell you from the case of Grand Lux suppliers that the non-compliance of those laws, because even the East African Customs Management Act was in extension also declared a rule of law violation. Okay? So these are some of the matters we have discussed already. Now the question is, if the High Court is going to deal with this matter, have we now arrived at the point that the High Court can deal with the matter? Is there anyone still in doubt that the facts as they are, the filing by in the High Court of Adnagu was wrong? Is there anyone still having a problem with that, but who still insists the matter is at EACJ? Because I want us to move together. So are we all on the same page that the filing at Adnagu High Court is okay? So far, we are on the same page? Very good. If we're on the same page, how then should the High Court deal with this? Again, let me remind you that in dealing with this, remember that you can invoke community law before the court. That's a principle we can do. You can invoke and enforce before national court. That case of East African Law Society is clear on that. But also in Charuenda, that question was whether indeed those articles are justiciable. And the court held that they are both justiciable before the regional and national courts. You get it? So both national courts and regional courts, there are articles that are justiciable before that. Now the question then is, under what circumstances can you, as a national court, prefer to deal matters? Because even when you have both jurisdiction, you need to have the technique of finding out where should I file? Where do I think I should go? Now, even when the court, in certain instances, has said we have jurisdiction, it has preferred that certain matters must be filed in national courts. Yes.
If you choose to file in the High Court, yes, and you're invoking the law on the treaty, is the time limit in respect of the treaty, the 2 months, applicable in the national court?
That's a very, very good question. Because we said yesterday you have that limitation of 2 months. You want to, okay, let's hear another.
Before you get to her, I also have a problem because we have a matter in there where we sought for the ECJ, the reference, but they've never given it to us for now 2 years. So do we? Yes. Okay. So my question is in relation to her. Yeah. Does the time limit still work?
Okay. You retain afternoon. Dr. Noria will sit here to try and advise people who have certain matters. He has graciously accepted to donate 2 hours in the afternoon. So if you have a matter of that, he will handle. But in my view, it does not. It doesn't, because the limitation was as a result of an amendment process. You get it? Now, it has not been litigated. I will find out from the registrar, because it has not been litigated yet. But me, if I am late today, I'll go to the national court. And I will argue that if they wanted to limit it to 60 days, they should have limited it. Since they didn't, yes, that's what I would do. I am persuaded that that is what I would do without blinking at all. I would file and make the argument any day. Your worship, what do you say? I put you on spot on 60 days. Maybe in terms of procedure, whether it has been considered.
Kindly repeat.
60 days.
Mm-hmm.
National court. It's a matter that has been considered.
No, it's not a matter that has been considered. Yeah.
So you can hear from the court it's not been considered. So we can try. Sometimes it's better to try and fail than not trying at all. But also in life you can try and succeed. And then you will have saved many people. And you celebrate. So if you have an option or to do things, it's better you try and fail than never try at all. Isn't it? So I would, I would try it out. And my reason is I understand where the amendment came from. After the Nyang Nyong'o case, the heads of state were very bitter. You can imagine the court put an injunction. The presidents flew to Arusha to swear MPs. In the morning, they are all there. And these are big people in their countries. You can imagine these presidents from EAC were in Arusha waiting to swear members of Yala, and they are told that there is an injunction. The function cannot proceed. You now assume in that room the power, what that violation and the disturbance it caused to these people, saying their ego was, sorted out. What is this court? We are the ones who put this court. We are the ones who appointed these judges. We are the ones who created the community. Who are they? Who are they? We pay, we do everything. Who do they call themselves? So they said, Attorney Generals, what can we do? Quickly to sort this court out. Quickly bring treaty amendments. 1, create an appellate division. 2, limit jurisdiction to 60 days. Limit jurisdiction to 60 days. And 3, ensure that if we initiate a disciplinary proceeding in our own national courts against any of these judges, they will immediately cease sitting on the court. So today, if you want to deal with a judge in EACJ, you can initiate a disciplinary thing and they deal with them and then they call them from the court. So they said, yes, let's teach them a lesson. Now, if you have a background of those amendments, I will say that Article 34 was not touched. Why? Because that was not the immediate pain point. The immediate point, there was no issue from national courts. Then, there's only one case that has come via Article 34, the Charwenda case. You get it? So there was no problem in the room to solve. Say, these citizens of East Africa, they are sleeping properly. No one is filing matters from their national jurisdictions. The lawyers are also happy not to file and advise their clients to invoke Article 34. So we okay, let that one lie. It's on that basis that I say you can proceed. Based on my history, personal knowledge of what happened, because I was told by a person in the room, but I shall not reveal my source. Because that was a very personal conversation, but leading to the background of the treaty. So, even when you can file matters at EACJ, the courts have expressed reluctance to address commercial disputes on grounds that these can be heard by national courts. You get it? So even when you can file there, the courts are saying, but go back home. The courts have jurisdiction, the framework is applicable. You get it? That observation was very soundly brought up in the Alcon International versus Standard Chartered Bank. Say this matter, you should have filed it in national court, not in Arusha. However, there is a duty by the national courts, back to Article 34, to refer disputes to EACJ. So if you file, there is a duty for the national courts to request for preliminary rulings. Like we've said, they are concurrent. That power to request is under Article 34. But we must understand the premise and the scope of the preliminary ruling requests by national courts. And to understand it, we need to start from what the courts in Charwenda said, the purpose why this mechanism is very, very important. In that case, they highlighted two things. One, preliminary mechanism is intended to enable national courts to apply EACJ interpretation to the facts of the case before a national court and to enable the court to make a judgment. You're empowering the national court with an interpretation for them to apply to the facts of the case to enable them make a decision. 2, the rationale is to ensure uniform interpretation and avoid possible conflicting decisions and uncertainty in the interpretation of the treaty. And the reason is not far-fetched. You don't want a court in Burundi, in a corner in Burundi, and another one in Garissa having different interpretation of the treaty on matters before them. So that is why the premise for the exclusive interpretation by the EACJ can be located. Of course, national courts have a discretion. Remember, shall and then what discretion, okay? If the interpretation is necessary, that discretion is narrow. But at all times where there is a need for interpretation, that is the jurisdiction of the EACJ. Are we clear? And the reasons I've already given them to you. But where the court has discretion under Article 34, that discretion, remember, shall, where necessary. That discretion is very, very narrow. In certain instances, the court will not or may not refer a matter to EACJ. And the court said, under 3 instances, and I want you to write this. I want you to write this, because in future, when you win a case, please remember. Remember this investment. Remember this investment. 3 areas where community law is not required to solve the dispute, an irrelevant question. That's what the court called it. In that situation, the court will not refer the matter to EACJ, where it is of the opinion that community law is not required to solve the dispute. It is an irrelevant question. Example, you have pleaded nothing on community law. Then you show up on D-Day and ask the court, my lord, my lord, my lord, my lord, this is a matter for interpretation. My lord, refer this matter. Then my lord, my lord, my lord. Then you say, no, how, where am I? Where have you pleaded? My lord, I don't have to plead. It is right, my lord, that this is community law. But the always says, but you have pleaded here negligence. Your cause of action is based on negligence. This is what we see. Show me anywhere under. Let's go to the under what law have you brought this pleading? My lord, no, it is right. Community law is now the fashion. We are members of the EAC community. My client traveled from Tanzania yesterday. He's enjoying the. It is an irrelevant question, and the court will not refer the matter. You have not pleaded. Okay? So that is one instance where the court will not deal with the matter. We get it? The second is EACJ has already clarified the point of law in a previous judgment, the principle of acte et clair. In a previous judgment, you know for sure. That's why we are giving you these materials. Because to appear in that court, you must show that you are, here we pass. Here you sometimes appear with counsel, and the counsel does not know the law at all. He has not researched, and here the level of we tolerate many things. But there is a principle in Charuenda that for you to engage these things, know some law. EACJ has already clarified the point of law in previous judgments. That means you must read what? Widely before you file. Because if the matter has been clarified by the EACJ in one of its judgments, the court will not exercise that discretion to refer it for a preliminary ruling, even if you request. The judge will tell you, if he's a judge who reads a lot like Justice Mubiru, will tell you, but my counsel, this matter has been canvassed in this decision. Have you read it? No, my lord. Then he say, but do you want to read it first? You request for time. Time out and drink some water. So that you proceed. No. There is no room for error. You have to have read. Thank God we are giving a litigator's manual and a source book. If I am in court, I'll put my hand up. Say, my lord, I'm a citizen, I'm not a lawyer. I attended the workshop where we gave this person the manual, litigator's manual, the decision is there. No, but I'll raise as a citizen. You haven't seen citizens putting their hands in court and the judge saying, yes, what are you saying? Said the lawyer is lying, I did not instruct them. You have not seen that? Remember that judicial power is exercised for under Article 126 in the name of the people and for the people. So if a person raises his hand up, he's the one who has given you that power to exercise judicial power in his name. As a judge, you cannot refuse to listen to them. Yes. So the third point is the correct interpretation of the community law is obvious. Acte clear. It is obvious. There is really nothing that requires interpretation. It's in black and white. Everyone who reads it's that plain. What amounts to being obvious? No. You have been tortured under the Anti-Torture Act. And they have Katavazi and all those things are clear that that is a violation of human rights. The evidence is overwhelming. Why must I send this matter for 2 months, 3 months in Arusha? Why? As a judge, when I tell you, but counsel, I can resolve this issue. It is clear. The facts are clear. The response is clear. Why should I? Yes, Doc.
No, I just wanted to point out that if you look at testimony mottos that Justice Mandrama held and then it went on appeal to Court of Appeal, Justice Bamugemere, that would be the typical case of the community law is clear. That you begin with an evaluation method based on the price of the good. Then you go down the scale until you have other means of assessing the value of the good for purpose of taxation. So that would be a good example that the East African Community Custom Management Act sets out a schedule of how you determine value and for purpose of tax. And the commissioner ignored that. So the question is, if that had gone to the East African Court of Justice, they would have said, but there's a schedule and it's clear what now there's nothing for us to interpret.
So that is, of course, as a lawyer, that is where your duty comes in, to do that. So in light of all those are the 3 areas where the courts will exercise discretion, not to refer. But if it is to deal with interpretation, despite 27 and 33, they have to go to EACJ. You get it? You get it? Have we understood that? So in light of that, let's come back to Northern Enterprises. So with that understanding now, can that matter be resolved by the High Court? The Northern Enterprises. Yes, now. Why? Why? Okay, there is East African Customs Management Act. The procedure is there. What else? We have already cited some precedents where national laws were violated, and the court has already said. Preferably, yeah. Super. I think you have understood. I can stop here. Yeah? Yeah? As the EACJ already clarified the point of law, we have said non-compliance of the partner states' national laws. We have visited all these decisions. Muhochi, Mukira, Attorney General. Praxeda Lugumba is another one. You know, Rwanda did not follow the procedures of their penal laws, and the court said you did not follow the procedures of your law, you violated that Article 6D and 7D. So when we are done with that now, let's quickly run through the procedure. That has been covered, but I just wanted to emphasize, you look at Rule 126. So in those facts, we will not need to refer, okay, for those reasons. But now we are going here just in the event that we have to refer. Where should we look? Always look at Rule 126 of the ECJ Rules of Procedure, 6th schedule. It's very, very detailed. Please go and look at it. The courts at any stage, they can do that. What they should do, they should define the factual and legal context and hear both parties and then refer. Then they should stay proceedings until the EACJ gives a ruling. I don't know for the one of leader whether the matter was referred, because it seems to have been stayed. Was it referred? Not referred. Not referred. What was the matter about?
Okay, the matter is an enforcement of human rights. So we sought for the reference to the ECJ. The judge asked us to file our submissions, which we filed, but before he could give a ruling, he was taken to another court. So the new judge comes in and we write a letter for this reference, and he says he cannot give a ruling in a matter that he did not hear or preside over. So now we are waiting for the former judge to give us a ruling.
That's a travesty. But now, in light of this discussion, do you think it is a matter that needs to go? I think I have my answer. I have, yeah, you can withdraw. But you can not say if you'll be condemned in costs. You rather say the time. The matter has been overtaken by events as a result of the delay by court in processing the matter. And then there the judge will withdraw without condemning you in costs. Right? Yeah. It's the beauty of such trainings. You get to know. Yes?
I'll use her example. If the judge is not making a decision, saying that it was heard by a previous judge, so can't I do one thing and can't I withdraw it and then I file it afresh since it is going to be under him?
I think two of you can have lunch. And yes.
Thank you, Senior Counsel. My question is, if you find that you don't need to make a reference and the judge decides to interpret by himself, so a precedent is made, and then a similar matter arises in another partner state, and then the judge there also makes a divergent interpretation, how are those divergent interpretations of the treaty eventually reconciled Because does that mean now if a similar matter happens, say in a third partner state, then the judge is at liberty to choose which interpretation best suits them?
I think if the judges decide to interpret, then it will be binding us between the parties until when the matter finds itself in EACJ, in one way or the other, and the interpretation that the EACJ gives will be the authoritative one as far as the treaty is concerned. But the challenge here is that even the judges, when we trained the judges last year, similar training, many of them really appreciated the fact that they had not engaged this system. So I'm not surprised that the judges, some of them push away the files, because until you understand something, it also can, you can, so they say, now that you have trained us, do you want, welcome Deputy Solicitor General and the team from Aegis. So the judges, when we did this training, they appreciated so much the training, and they said, now that you have trained us, please also train the advocates, so that we are all on the same page. We can help each other, because the quality of the bench is also dependent on the quality of the bar, and vice versa, isn't it? So in summary, what I want us to understand, that that state of proceedings, of course, when they make a reference to EACJ, then he will stay the proceedings and wait for the preliminary ruling to come. Now, that's the challenge. The timeline is not provided for. And I think that has been the frustration of many people, saying, if this thing goes to EACJ, how can they hear it quickly? But what I know, the judge president is on his way, but I think they now understand the urgency of fast-tracking these matters. Why? Because a decision is being awaited for in the national courts. So in terms of precedent and in terms of fast-tracking, we see them fast-tracking this. So the procedure under Rule 126 is by way of a case stated. You state the case for the EACJ to make a decision on. So how is that transmitted? The national court sends the documents to the EACJ by registered post. So the post office is still important in these things, okay? Addressed to the EACJ registrar or sub-registries. Now you may wish to know that we have a sub-registry for EACJ. In the early days, you can imagine every time we had to fly to file, then return. But the court has now deemed it necessary to make the court accessible. They have put a sub-registry in each country. Do you know the one of Uganda where it's located? Supreme Court. You look where for the Supreme Court is, there is a registrar there for EACJ. It's there. Your worship, do you want to clarify on the registry here, where it is and who is in charge for the participants?
Thank you. I think I did mention this yesterday during my presentation, but we have a sub-registry that was situated at the Supreme Court premises, but I believe they are going through renovation right now, so they are located in Wandega. There's a court premise, yes. So, and the person who's manning that sub-registry is a clerk. He's called Simon Tweng. So once you go there, if he's not there, then you'll find a notice with his phone number. So he's ever accessible if you really want to file a matter. Thank you.
So please don't bill the clients for flying to Arusha to file You know, business class council use business class. When you use economy and it's not necessary, please don't do that. You file here in Uganda. So your disbursements must be transport from your farm to where Supreme Court is. Yes, the number is there. You write an email to her worship. She will give you directions. So there is a very pertinent issue for you to note which ties into the purpose of this preliminary mechanism. When the EACJ registrar receives the relevant documents, he is required under the rule to notify partner states and the Secretary General and the organ or institution of the community that adopted the act, the validity or interpretation of which is in dispute. Now, when you read Charuhenda case, you will find that the dispute was referred by the Attorney General of Uganda. But inside, you will see that the registrar notified all the Attorney Generals of all the countries. And they made representations on the matter. They gave their opinion on they make submissions on the matter. The reason is very simple. Uniform application of community law. Because the decision in Charuhenda is applicable across the partner states. So that's why you give opportunity to the partner states to make submissions. So that is what the registrar does with that. Then, and the Secretary General, of course. And under 6th Schedule, Guideline 5, parties and other persons are notified of the date of the proceedings. At the same time, the statements of a case or written observations are served. Then there is a presentation on them, you know. And when you go through the rules, the EACJ, the appellate division, of course, will deal with this. And under the schedule, all those guidelines are there. There is an oral part under 6th Schedule, Guideline 9. ECC may request clarification from the national court that has requested the preliminary ruling. May, if the factual statements are not clear for the court, they will do that. Now, importantly, once the ruling is made, the EACJ registrar sends the national court copies of the procedural documents and also notifies the partner states, the Secretary General, and any interested organ or community of the ruling. That is something that they do. And the reason is, again, to ensure that everyone who has submitted or who has declined to submit receives the decision, the ruling, because it is binding to the community. The EACJ has that jurisdiction for treaty interpretation. So that's what the procedure would look like. And from the problem that we discussed and the cases, I go back very briefly to summarize and say two things. Jurisdiction of the court is provided for national courts. On the face of it, under Article 2733 and Article 33, they seem like they can interpret. But when you dig Article 34, okay, very clearly, and you unpack that discretion under the Charuhenda case, you'll find that that discretion is very, very narrow. Again, I go back to it. That discretion is in those three areas. You get it? Community law is not required at all to solve the dispute. EACJ has already clarified the point of law in previous judgments. The correct interpretation of the community law is obvious. So if the court, under any of those grounds, finds that you don't meet any of those, then they will exercise what? That discretion. Yes.
Some more light on number 3, because I think number 3 is very subjective. When you say that the community law interpretation is obvious, what might be obvious to the bench might not be obvious to the bar. And in case I'm dissatisfied with the decision that of the judge saying that it is obvious, but me I see it's not obvious, I need interpretation, what can I do?
For instance, we have labored to say that if you violate your own national laws. Okay? Now, the EACJ has interpreted that is a rule of law violation. Is that now a contentious matter anymore in the community? For anyone who has been practicing in or has read, as you will read both the source book and the litigator's manual, you will find that the correct interpretation of the community law, as far as the place of violation of your national law is now it's the correct interpretation is obvious now. That if you violate your own national laws, then the position of the EACJ is that they no longer need to interpret that matter. So whether you talk about Praxeda Lugumba, the violation of the penal law in Rwanda, whether you cross over to Uganda and look at Henry Charimpa, the violation of the PPDA laws, when you look at Samuel Mukira versus Attorney General, you arrive at a place that community interpretation on violation of national laws is now obvious. Indeed, as you will unpack the source book and see there, you will see that that's not an issue that now you can take, for interpretation. It is for application by the High Court. Okay? The interpretation has already been done. It is for application. You are making the argument that this violation of this law infringes Article 6D and 7.2. The procedure in this law was not followed. Therefore, it is a violation of rule of law principles enshrined under 6D and 7.2, isn't it? Yeah, that's one example. But also, the testimony case, I think you need to read that, the one of testimony motors. The procedure, how you do evaluation, customs valuation. When you read the law, you will find that it's actually obvious, just from the law. But of course, URA has to meet its target. They will try to collect as much tax as they want. So what then you see until it's challenged, and you see all from High Court, Justice Madrama to the recent decision by the appellate court, it would appear that that matter, even when it has threads to East African community law, is a matter that does not require interpretation. Yes, it's possible.
But Senior Counsel, I think that exactly was the point he was trying to raise, that if, and I'm repeating it because I'm not clear on your answer, if a national court refuses a request for a reference, for a preliminary ruling, does the party have a remedy from the regional court?
No, you have a remedy through the appellate mechanism. If, for instance, you file in the High Court and the court declines to grant you a preliminary, to make a request, you cannot appeal directly to EACJ. You have to appeal using the internal route. You get it? Because the EACJ does not have appellate jurisdiction over domestic courts. So you have to exercise the appellate jurisdiction nationally. So you go to Court of Appeal to ask them to refer.
Or file directly. Or file directly, not necessarily appealing, but just filing directly.
Yeah, if you can find a treaty violation and you are still within time, remember, 60 days, the court has been very clear on that. They don't have the latitude to expand beyond the 60 days. So if you are in time, you will. If not, even if you are late by 1 day, the court has been very, very strict that you will be declined audience on that matter. Okay, so any other questions, comments? We are in a good place for questions now. I have basically finished. I think now we are in a good place.
Yes, name is Mark. From the discussion, it seems like it is the court that is supposed to ask for the preliminary ruling. What if, for me, I feel like I need it, and even on appeal, I appeal to the next court, and the court is still not requesting for it? But for me, I know. What am I supposed to do then?
Now the students who have understood also ask. That's how
So I will answer what I have understood. I'm not saying I've understood, but what I've understood. What I would do is I would bring a fresh suit, like Francis said, similar to the case of Martha Wanjiru. Can I just file afresh? It's an answer and again an inquiry for further clarity from you. Can't I file afresh to the EACJ and coin my suit under rule of law? Again, the same principles. Just like in the case of Martha Wanjiru.
His question was, you can move court. Let's start. That you, as a lawyer, you can move any of the parties. Indeed, in Charuhenda, it was the Attorney General who moved that the matter be referred. So you can move the parties, you know, as a lawyer for one of the parties. Okay? So that is settled. If the decision is against you then engage the appellate mechanism within the jurisdiction. Counsel, litigation must come to an end. If you have exercised the appellate mechanism and you don't have an answer, that's it. You go back home and close and leave to fight for another. We cannot litigate forever. You are given some mechanisms. If you have exhausted, that's it. Accept. Accept that that is as they normally say. You can, in anger, you see some lawyers addressing the press conferences after they have lost. You say, I don't agree with the decision of the court, but I will respect it. So maybe at that point, that's how you can express your anger and go home. But yes.
Thank you so much. Does the appellate court have jurisdiction to review their own rulings?
The appellate. Under the rules, you can, but it will be very rare, but you will be maybe innovating under the general discretion of the court. You can move under that power to review, but you know the review of decisions normally are slip rules. And you know what that rule is about. Minor errors, arithmetical errors. You can invoke the general discretion of the court. Yeah. So we are coming to the close. The judge president is here.
Thank you, Senior Counsel. On the time limit, can I seek leave to file out of time?
If I may answer, re-echo your words. You said the courts have expressly stated that they cannot enlarge time. But my question is, my question really, this is prompting, I'm saying the fact that, mine is cardinal because this is a very important court on matters of interpretation of the treaty. So have there been discussions either at the summit level or council of ministers to look at a way of amending to enlarge time? Because you can't close out a litigant. Yeah? In case of a violation by a country like Uganda, I need to carry Uganda to the EACJ. So really.
Yeah. I think that is a question where you, as lawyers, exercise your civic duty to engage government and persuade them why you need to extend that. But strictly speaking, the court have taken a very strict approach on issue of timelines. If you are out 60 days, you are out. And I agree with that interpretation because it is mandatory. If you read the treaty provision, they don't have discretion to enlarge time. They don't have. It's just like us in the PPDA Appeals Tribunal. The law parliament gives us 15 days to resolve procurement disputes. So we don't have discretion to enlarge time. It's statutory, where time is tight. Yeah.
Hello? Just before you ask your question, the court has indicated that it cannot enlarge time where it's not under its control. In this case, the treaty which sets out the 2 months limit. But if it is enlarging time where the court is handling matters, so for instance, you want to file your appeal, but then you discovered for some reason you didn't file it within the time set out, then you can apply for enlargement of that time, because that is for the court to do. But the 60 days, the 2 months, that's not outside the court's control.
Thank you, Senior Counsel. My question is, it wasn't answered yesterday, on the directives, the ESC directives, can they be enforced directly by the regional court or the national courts without the requirement that they be domesticated or that an act of parliament be enacted to reiterate the provisions of the directives? Aren't they part of the treaty laws? Then the second question is, could you maybe mention more about the remedies that we get from this court? Because yes, you've done all the work, you've done all the pleadings, but what remedies are you expecting beyond a declaratory maybe order? Do they give, are there sanctions? Can you sanction a country like Uganda? Do we have precedents where the court has sanctioned a particular country for an infringement? Or are there costs, damages? Basically, remedies and enforcement of those remedies. Thank you.
On the first matter, I think we have to start from where Dr. Honoria started yesterday. What is ESC community law? Treaty, directives, everything. First of all, let's start from one thing, that the ESC treaty, there was a requirement that it be made an act of parliament of all partner states. So it is the ESC Treaty Act, it's actually an act of parliament of Uganda, meaning whatever flows from it, protocols, directives, you can litigate on that. That is a big yes. The second one is on remind me? Enforcement, yes. Yes, remedies, basically remedies is for you lawyers. When the court started earlier, it was majorly declarations. And when you look at the first 5 or so years of the court, those decisions, you will find their declarations. Many times, until after some time, you kept, just how with the lawyers, you creatively begin to bring matters. I think it was not until the Margaret Ziwa case that we saw damages coming in, and the moment the window of damages was opened, then as lawyers you begin to plead to justify why you need damages. And there is a matter where we crossed the $1 million damages mark, which was the first. You can imagine that was a huge issue, but over time. But at the end of the day, it is you, the lawyer, to persuade the court about the remedies you want based on the law, you know? And some of the remedies, we had to look at what was happening in other international settings, and you make submissions based on that. So yes, the court has been very accommodative of late to granting remedies if they are persuaded properly about the case and where there is a finding. So that's why we are called to persuade based on the law. Yes, basically, the court does, you use the national courts system enforce. But what we have seen over time, that the countries have been respecting the decisions of EACJ. Though now I am seeing one partner state that is beginning to be problematic, but we'll pray to God that the spirit of respecting the court without enforcement and execution, it continues. We have come to an end. The judge president is here, the deputy solicitor general is here, and accompanied by very senior officials from the state law office. Allow me say thank you. We'll continue the conversation, and after the official ceremony, I now hand over the microphone to Her Worship Christine to manage the next process. Thank you.
Thank you very much, Francis, for a very enlightening session, and I believe that everybody has been able to gain from this session. My Lord, the Judge President, the Deputy Solicitor General, all attorneys present, we've come to the end of our two-day training, and it has been such a great opportunity for the lawyers here to not only interact with the courts through our presentation on the court's mandate, its jurisprudence, as well as its function, but also to be able to get important feedback following a case study that was given by Dr. Honoria that enabled them examine issues or matters that are brought before the court and how best to resolve them. So for this session, I'd like to request the Judge President, the Deputy Solicitor General, and Mr. Gimara to please come and sit at the front. So, my Lord Judge President, before we can end this session, I thought we could have an opportunity for you and the Deputy Solicitor General to just get a brief rundown of what the session has been over the last 2 days from Mr. Francis Gimara, who is the Program Director of the Center for Public Interest Law, the main organizers and our partners in the convening of this training. Thank you.
My Lord Judge President, the Deputy Solicitor General, who is representing the Attorney General in this meeting, it's with pleasure that I welcome you, of course, Your Worship, who has been part of us these 2 days, and indeed all of you are esteemed participants of this training. My Lord Judge President, before you are advocates who were carefully selected from very many applicants from the Ugandan Bar. As you note that we increased the number. Normally we do trainings for 20, but because of the demand by the advocates, we have had to increase the numbers by almost twice. We have spent 2 days in this place, and as you are aware, my Lord Judge President, part of the reason for this training is that the East African Court of Justice has, through its strategic plan, deemed it necessary to be a court that promotes the values and the principles upon which the EAC Treaty stands. That the court has done very convincingly, and as a result, created very admirable jurisprudence. And for many of you who don't know, that across Africa, if you read journals and literature about courts that are functioning in line with their mandate, the EACJ has been highly rated by academics and stakeholders across the globe. And because of that, the Center for Public Interest Law, together with Ford Foundation, we have deemed it very necessary that the jurisprudence that has originated from this court reaches out to the citizens through their advocates. And the best way to do this has been to compile 2 resource books that have been compiled under the leadership of our technical director, Dr. Honoria. These 2 publications, I must say, having litigated in that court for more than a decade, you cannot find in any one place, at least for an advocate, material that can make it very easy for you to plan and prepare matters before the EACJ. We have prepared these materials in form of a flash disk, and the reason is very simple. We have created hyperlinks to that, meaning that in as much as you will have a summary of the decision, for those of you who want to compile a list of authorities, for your litigation, you don't have to walk out of your desk. With that flash into your computer, you can easily attend to a matter much faster, much easier. And we did that because earlier on, we were challenged when we set out when the court started. We did not know what procedure, but over time, the court has clarified the procedure through decisions, through the 2019 rules of procedure, and of course, as well as the court manual. So we are in a good place. We are ready to take off, all of us, the advocates with this training. Our expectations, without contradiction, is that we will engage the legal architecture with understanding and with depth. At the end of it all, the principles that we are promoting are not being innovated, are part of the treaty. The creators of the community understood that to build a good community, you need good governance and you need the rule of law. And they put it in the treaty that this will be fundamental principles and operational principles for the effective realization of the objectives of the East African community. So they signed onto that treaty, they made a commitment. What the court has done is to remind them continuously of this commitment. And this training is further to train more apostles to jump onto this train of promoting good governance and rule of law in East Africa. So we hope the 2 days has been what you call a good starter to the meal of EACJ jurisprudence. The main meal is served and it is in your flash disks. Thank you so much for listening to us. As Center for Public Interest Law, our objective is one, that we make public interest. We use law to better the public we serve. And through training you, we have met that objective. So go ye into the world and preach the rule of law and good governance. Thank you, Judge President. I commend you sincerely for making time to come and close this workshop. As you know, the Judge President is very busy, but he flew in because the court recognizes the importance of this training and this partnership. And we thank you. We thank you, Your Worship, for being part of this from the beginning and for coordinating and being very effective in supporting this. Thank you, Deputy Solicitor General, for coming to be part of this. And you know, the Solicitor General and Attorney General's chambers are mainly the respondents. They have, we invited them, but somehow the communication did not arrive in good time. But we have agreed with them that we will have a separate training for them, Judge President, so that we also train the respondents. At the end of it all, we all win. When the respondent is effective, the applicant is effective, the court is effective, we enjoy the practice of law. When one of those groups is hurting, we all hurt. So it is upon us to be better and to have all of us to be empowered equally so that we articulate the law in a manner that will make all of us proud, isn't it? Thank you. Lastly, I thank the team at CEPIL, Dr. Noria, the ladies at the back, Christine, Judith, Priscilla, thank you for the support to this training. Thank you. I now hand over to you, Registrar.
Thank you. Thank you very much, Francis, and the entire team at CEPIL, who have done an amazing job. First of all, initiating this training and calling upon the court to partner with them for this successful trainings. This is the fourth of the trainings we have had so far, and the intention is that we conduct the trainings in the other partner states that we have not been to. So with that, I would also like to invite the Deputy Solicitor General. We appreciate that you've been able to come and join us today. The AG's office is a key stakeholder of the court, and your presence here is not in any way taken for granted. Thank you.
Thank you very much, Your Worship, my Lord, the Judge President, Mr. Gimara, and all distinguished colleagues in the practice. First, I bring the apology of the Attorney General, the Deputy Attorney General, who was supposed to come here and actually asked me to come here at very short notice because he was called away. And he gave me his remarks. I don't know whether you want me to read them. Yeah.
Please do.
I think I'll read the remarks of the Attorney General that he asked me to present here. So, my Lord, the Judge President, Your Worship, distinguished guests, ladies and gentlemen, on behalf of the Attorney General's Chambers and the Ministry of Justice and Constitutional Affairs, allow me express our profound gratitude and appreciation to the Center for Public Interest Law and the East African Court of Justice for organizing a transformative training program on good governance and the rule of law in the East African community for Uganda's advocates. This training program has undoubtedly played a pivotal role in enhancing the legal capacity and skills of our lawyers, particularly those who appear before the esteemed EACJ. The East African community brings together countries with diverse resource endowments, socio-economic backgrounds, and political histories. These member states have joined hands to create an economic community that fosters cross-border trade, investment, and the free movement of people. The cooperative framework of the East African Community aims to strengthen the competitiveness of member states, both within the region and on the global stage. To ensure a level playing field and foster fair competition based on market economics, it is crucial to address the disputes that may arise within the regional integration process. We must recognize that the East African region is part of the Great Lakes region, which has experienced conflicts in the past. Therefore, the existence of a robust dispute settlement mechanism is vital not only for the existing partner states, but also for the prospective members of the community. A strong dispute settlement mechanism includes national and regional courts serves as a significant incentive for foreign investors who seek certainty and predictability in resolving potential disputes. By establishing the EACJ, the EAC aims to address trade-related conflicts and promote economic development. This mechanism plays a crucial role in reducing tension between countries and providing a peaceful avenue for resolving disputes. In line with this vision, the EAC Treaty established the East African Court of Justice as the judicial organ of the community. The EACJ's primary objective is to ensure adherence to the law in the interpretation, application, and compliance with the treaty. It delivers judgments on matters referred to it by partner states, the Secretary General, or any resident in East Africa. The court's role is instrumental in developing policies and programs that deepen cooperation among partner states in political, economic, social, and cultural fields. The training program conducted by the Center for Public Interest Law and the East African Court of Justice has provided our advocates with invaluable knowledge and insights into the rules and jurisprudence of the court. It is our sincere hope that participants have had the privilege of learning from the extensive jurisprudence developed by the EACJ, equipping them with the necessary tools to navigate complex legal challenges and present compelling arguments before the court. This enhanced understanding of the court's rules and procedures will undoubtedly contribute to the participants' effectiveness as legal practitioners. The Attorney General's Chambers is one of the active users of the court, with a significant number of ongoing cases before the court, and would also greatly benefit from the enhanced knowledge and skills acquired from this program. I would like to take this opportunity, therefore, to once again express our deepest gratitude to the Center for Public Interest Law and the EACJ for their unwavering commitment to the advancement of legal education, justice, and the rule of law. Through their efforts, they have contributed to the development and progress of the East African community, fostering an environment of fairness, justice, and respect of the fundamental principles that underpin our shared values. It is our sincere hope that the knowledge and skills imparted on our advocates will undoubtedly strengthen the legal fraternity within the East African community, ultimately leading to the promotion of good governance, rule of law, and the achievement of our collective aspirations. Thank you. Signed, Honorable the Attorney General. Thank you.
Thank you very much, DSG. I would like to now invite the Honorable President of the East African Court of Justice to give his closing remarks. Karibu. Yes.
Thank you very much, Christine. My brother, the Deputy Solicitor General, representing the Attorney General of the Republic of Uganda, Senior Counsel, Gimara, legal practitioners, age people, the Ford Foundation, my brother, Dr. Honoria. You know, this journey has come from very far. I remember when we were closing our first round of training last year, I personally requested Mr. Gimara to organize this second round of training, and he accepted. Thank you so much, Mr. Gimara, for accepting. First of all, I wish to inform you that very recently, in our last session, appellate division session in May, the Attorney General of the Republic of Uganda appeared personally in court. So the Attorney General has been appearing sometimes personally, either online, but very recently he was attending physically in Arusha. So that is a good sign that the Republic of Uganda is also giving credit to that court by the Attorney General of the Republic of Uganda coming with a team of government lawyers to appear personally defending the interests of the Republic. Instead of sitting there and lamenting because the Republic has lost, it is better that the Attorney General also appears personally, because he is the principal legal advisor of the government. That one was very good, but also in that session, the court took a very serious decision because of the behavior which was being observed in that court from Uganda, where some people just come and adopt sort of behavior in the court. So the court took very serious decision and gave some guidance to the Attorney General to make some investigations on some behaviors of lawyers, but also of other Ugandan litigants. Because the East African Court of Justice, being an international court, it must be an international court and also respected by the lawyers, also by the litigants. It is why we are organizing this kind of training. But also, the issue of rule of law and good governance, as Senior Counsel has already said, those are some of the fundamental and also operational principles under the treaty. So almost 90% of the cases which are there, they are being filed over Article 6CD and 7.2 on fundamental and operational principles of the community. It is why, for me, I'm lucky, because I've been appearing before I was appointed judge, almost more than 10 years there. So since 2009, I was the principal legal advisor of the government, and I've been appearing to that court. So in that jurisprudence, I'm there. I'm there as a government lawyer, but also I'm there as a judge. So I know that we must have good lawyers. Because if you don't have good lawyers, you don't have good jurisprudence. And we don't have good jurisprudence, we don't have good judgments. And also, if we don't have good judgments, our community is taken at stake. So this kind of training on good governance and the rule of law are key. We have been saying on declaratory orders made by this court, our court. Last year, if you read the Mbinde case, that is the Republic of Burundi, because Mr. Kimara said that the Attorney General is always respondent. No, Attorney General may also be an applicant. Yes, because the Republic of Burundi was an applicant, and when we started the case, it was the first case filed by the Republic, the government, and I was defending the case, and I lost. And I lost. It is the first case I lost. And the appellate, I was not there as a government lawyer because I had already been appointed a judge. And also the government appealed, and they lost. When the government lost, the government was charged to pay 350,000 USD as damages. And the government and the litigants, they sat together and they agreed to be paid 230,000 by the government of Burundi. In December, Burundi paid the total amount of 230,000, which has been charged as costs of the case. So for us, we are happy that what we are doing, the governments are respecting. And I don't know how they cannot respect. Because the way the judges were appointed, we are designed by our heads of state, and we are appointed by the summit. So if they don't respect our judgments, what signal will they be giving to the public? So we are happy. So Mr. Gimara and the team, and also the Deputy Secretary General, I thank you so much for taking this time to come and participate in this kind of training. Because in the past, some lawyers were very reluctant to be trained. We are not only training the lawyers, we are also training the judges. Because in the past, there is a French statement, which is not good, saying, La Cour connaît le droit, meaning that the judges, they know the law. They should not be trained. But we saw that it's not true. So we are training the judges, also we are training the lawyers. So the training on rule of law, good governance is good training. I'm sure you have gained something. I'm sure you have gained something. Go and read our jurisprudence. We are making our job. We are deciding our cases without fear, without favor, and we are doing our job independently. There's no interference with our job, and I'm sure we are also trying to discipline some people, especially from Uganda. I don't know why. I can assure you, my brother, Deputy Secretary General, we are trying to discipline some people especially coming from here, only from here, not from any other country from the East African community, who think they can just write rubbish to the court, insulting the judges, and just come to court. No, we are trying to see what you can do in Uganda, don't come to do it in Arusha. And we took very firm decision, and we instructed the Attorney General. So we took the decision, those people now are not allowed to file any matter to the East African Court of Justice until further notice. So what we are doing is also for the interest of justice. That the court, the lawyers, we are the same family, but we must do our job in a respective manner. So this training is key. If lawyers, you are conversant with the rules of the court, with the treaty, with the law of the community, we are sure you can also defend very seriously, effectively, efficiently, also the interests of your clients. It is by also knowing the treaty and the law of the community and jurisprudence that can do a good job. So the way we are interacting with the government, with all the governments, the Attorney Generals, we are good collaborations with the Attorney General, but also with the lawyers. With the lawyers, except some, yes, but we are trying to do whatever we can do so that we make sure our community is a very good community as regard to law, good governance, and the rule of law. Otherwise, I thank you so much. I know I saw the certificates, and I'm sure this training is not the end. Even the other one will be organized from here. I think next time they will be in Burundi, they will in Nairobi, in Dar es Salaam, in other parts of the community. We are trying to make good jurisprudence. I can assure you, if you go and read that Burundi case, the Ziwa case, The Martha Karua case, very recent Martha Karua case from the Supreme Court of Kenya, and other cases from the community, you will see that the court, we are doing a good job. But also, we are doing a good job because of you, that we are defending very properly your clients, but also the interest of the government. So I think the CEPIL and the Ford Foundation, the rule of law and good governance are key principle of the community. And I request Mr. Gimara to come back to Uganda, and also in the other parts of the community, so that at least we have very good lawyers. Because even in court, when we are interacting with the good lawyers, we can feel that we are interacting with people who are sitting in the court. When a Gimara is appearing to court, we can feel. That's why we are interacting with the good lawyers. When the Attorney General in the team, now the Attorney General has put in place a good team of government lawyers dealing with the East African community matters. So if we interact with the government lawyers from Uganda, now we can feel that we interact with people who understand the law. So we have even advised the other governments to do what Uganda has done. Because it is not, Uganda has put in place a team of government lawyers, state attorneys, who are dealing with cases from the Eastern Court of Justice. And you can see, when we are reading the prison from Uganda, from government, you can see that they have been prepared by knowledgeable state attorneys. But also, even for the private lawyers, legal practitioners, when we interact with people who understand the rules of the court and the treaty, we feel really proud that we are interacting with people who understand. So this team, we are sure, at least now the community has grown, with the DRC coming to the community, with more than 300 million people. Now the court is also having arbitration and mediation jurisdiction. So now, there is no use, there's no way now the legal practitioners cannot come to our court with this arbitration, mediation, but also with other mandate of the court. So otherwise, as I conclude, I wish you a very good trading. Of course, I'm sure you have got something. The community is here. All the partners now are in Uganda. They are celebrating the second annual for the Kiswahili Day. All the partners are here in Uganda up to 7th of July. So Uganda now is full of East Africans here from yesterday up to 7th of July. So even myself, I'm here up to 7. I wish maybe next time I will meet you in Arusha, practicing what we get from this training. And this marks the end of as I conclude, I just declare that this training on strengthening a civic space, good governance, and the rule of law in the East African community, which was being organized in Uganda for 2 days, officially closed. Asante sana.
Thank you very much, Judge President. So I'll just brief on what is going to happen next. So we have the source book and the litigator's manual that Mr. Gimara was talking about. And we are going to give this out officially to the Office of the AG, as well as the Uganda Law Society Library. This will be followed by the awarding of certificates, and thereafter we will have a group photo. So with that, I would like to invite you and the DSG, right on the right-hand side of the DSG, so we can hand over the source books. DSG, as you take your seats, I'll ask the Judge President to remain standing. And I would like to invite Rebecca Twine and Anne Karunji to please come to the front to receive your copies for the ULS library. Thank you very much. So we are now going to award the certificates, and I'll call out your name. You'll come to the front, receive the certificate. Judge President, I request that you stay standing. Then you'll face the camera, have a picture, and then give way for the next person. So I'd like to call upon Soita Jesse to please come forward. Yes. They need a picture with you. Onyango David Emmanuel. Is David here? Okay. Can I have Luima de Clark? Mayanja Noah will be next. Please prepare yourself to come forward. Serada Tony, right after Mayanja. We have Kawanguzi Mark. Rebecca Atwine. Gloria Oloya Awor. Leku Winnie. Kisache Joshua. Kakoma Edgar. David Okelo Owin. Hope Diane Masawi. Sharon Murunji. Joan Aka Kikunda. Namudu Janet. Please hold on. Let them have their photo. Sorry. Thank you. Daniel Baitwa Babo. Kaitesi Zerida, prepare to come forward. Alinda Rachel. Aima Patricia Oko. Omara Daniel. Ann Karunji. Brenda Christina Simwe. David Oluka. Cynthia Caron Poza. Speciosa Avaco. Lilian Bulia. Namirembe Sophie. Nanziri Farida. Nanyonjo Irene Deborah. Tusime Agatha. Paul Muchibi. Tumwesi J. Francis. Atham Peyre. Kigonya Christopher. Is Christopher here? Please move fast. Mufumba Victoria. Is Victoria here? Joanne Atukunda. Jimmy Michael Gwang. Mbabali Jude. Anthony Nasasira. Kemisto Schweib Kubai. There's an error here, but I think you'll rectify it once you receive the certificate. Thank you very much, Judge President, and thank you to all the trainees once again. So I'd like to invite us to have a group photo. May I kindly request the DSG Judge President, Mr. Gimara, to please come and stand in front. And Dr. Honoria, kindly. This picture will take it standing, and then thereafter we have the group picture. 5 chairs at the front, please, and everybody else stand behind.
Hello, everyone. So it's time for us to go and have our lunch. I would like to request for people to pass at the table at the exit for your lunch coupon and a copy of the flash drive.